everyone, and welcome to episode 15 of Data Matters on what is a beautiful afternoon here in the UK.
I'm Vicky Gilwell, partner at Privacy Culture, and I'm here with my business partner, Steve Wright.
Hello.
And a very warm welcome to Robert Bond. Robert is a partner at Bristow's LLP.
We also have Stephen Bond, who's Information Rights Manager at the Open University.
Hello.
So today's topic is retention and deletion. Now, this is something that traditionally has so often been an afterthought, and perhaps it feels like it should be at the end of the process, which is probably why it usually was forgotten in many cases. I'm sure many IT professionals have had a bit of an I told you so moment over the past couple of years, because they've been telling us for a long time that to optimize our systems and processes, we need to make sure that we have a retention schedule in place and we are regularly deleting the information that we don't need. But now we are truly obliged under the GDPR to get this right. So let's hear from our guests on what this requirement really means. And I'm going to put the first question to Robert, if I may, for you to unpick for us what retention and deletion actually means under the GDPR, please, in legal terms.
Thank you, Victoria, and thanks for having me on the session today. Well, I suspect most of you have read Article 5.1 of the GDPR, which is really where we get the retention requirement from, in that it says that you have to keep personal data in a form which permits identification of the data subject for no longer than is necessary. And that's really where the challenge starts, because nowhere do you find in GDPR a definition of what is longer than is necessary. We also know that Article 25 of the GDPR, which deals with data protection by design and default, again tells us that where we are keeping data for specific purposes, we have to make sure that we've got in place adequate technical and organizational measures to keep that data secure, and that the obligation to keep it secure extends for the period for which you have collected the data, the extent of the processing, and the storage period. Again, we don't specifically see the word deletion, but you can draw from the language of GDPR that when it is no longer necessary, then you should not have personal data, and therefore it should be deleted. Simple?
Thanks so much, Robert. It's actually quite a comprehensive area of the regulation for something that is seemingly so simple. Stephen, I wonder if you can start to talk about some of the problems that organisations might have with addressing this particular requirement.
Yeah, like Robert said, it should be simple. It's not necessarily so. A lot of people have, or a lot of organisations have system restrictions that maybe GDPR wasn't around or wasn't part of the planning and implementation of those systems. So legacy planning and things at the time were not built with retention and deletion necessarily in mind. Certain organisational challenges that companies might have in order to disseminate the retention information to people and monitor the uptake of that, and providing people with a space to be able to work within that, particularly where it is their own data, their own unstructured version of data, email data, shared area data. The sheer volume of that makes things very difficult to manage the deletion process or to determine how long it should be retained for. It, leaves the decision making very much at the point of the individual to make that. So where you've got structured systems, you can define the retention period for the different areas, different points, very much down to a very granular level. Where it's more unstructured and there's less metadata around it, you can't necessarily follow that process through. It's a lot more difficult to do. And quite often when it is brought to the attention of a company, it's linked to dissatisfaction or a complaint. So people will understand that we've got their data, that we maybe shouldn't have their data, and that creates a wider issue for the companies.
Thank you, Stephen. Yes, so I guess, you know, the introduction of GDPR has actually made a difference to the level of risk that the business is facing from holding on to data too long, essentially.
It's it's entrenched it in the data subject rights, you know, the right of access, the new right of erasure, where deletion has to be involved. So people can ask for their data to be deleted at a time that is outside of your retention or deletion schedule, and obviously not a qualified right for it to be done. If there is a reason, as Robert alluded to, for us to retain the data, then you can do, and you would need to communicate that accordingly. I think the deletion part of it is aimed more at transient data, marketing data, inquiry data, things like that. The other risk is the time limits that are imposed within it. So you have to delete them with erasures and subject access requests. You need to respond within a month, and that's now in statute that's something. But you also have to apply those time limits to each area of the data that you're referring to. And fines are starting to be levied now. Spain has recently fined a company €250,000 for not documenting and implementing deletion at all. So it is something that is becoming more prevalent. People are exploring the arms of the GDPR. And the other big risk that stood out to me was more around not knowing what the data is. So having an idea of what your data is, and not being able to identify retention or deletion, puts the company at quite a considerable risk, because you don't know where it's going to fall, you don't know where it's going to breach, and you don't know where or when it's going to be deleted.
Thank you, Stephen. And Robert, have you got any builds on that in terms of the types of risks that organisations might face in this area? I mean, Stephen alluded to information rights requests. Perhaps we can drill into that a little more.
Yeah, I mean, just before I do the individual rights requests, I'm somewhat cliche, but we all know, everybody says, you know, data is the new oil of the internet. Likewise, I always say, you know, please don't have a gusher. And that's the problem, is that when it goes wrong, you wish you'd not had all of that data. And we do have you know, and Stephen's got more of a challenge with this than, say, I do as an external advisor, but the business wants to hang on to data just because you never know when we might not want it. And that's not the way it should happen. So what we're seeing when we get an individual who exercises their right, whether it's access or it's the right to rectification or the right of erasure, more often than not, they are not happy people. And if you can't respond appropriately within the time limit, they are going to enjoy making your life hell. They can report to the ICO. They're waiting for you to be caught out. And one of the challenges that I've seen with a lot of clients is often the business overall doesn't actually know where all the data is. IT will tell you, we know it's on the enterprise-wide network. We know that we've got a third-party cloud provider. We know that individuals have got devices, but then it's all the other stuff, like the head of HR who still likes to keep all of the HR records on her personal computer at home, or insists on printing out the bios of anybody who's ever applied for a job, and nobody knows where the physical paper is. And actually it's worse now in the working from home scenario or the remote working, because not everybody has got the benefit of a VPN access or a corporate device. And now we are storing personal data while we're working from home in multiple locations. And that's where we're going to see some real issues. Even when we go back to work, how do we get the stuff off the personal devices back into the central server? And as I say, some of the instances I've seen is the aggrieved individual is the one that actually knows where everything is, and they are just waiting for you to not respond properly, and then they will report you. And really, you've got no excuse when you come to look the regulator in the face, unless you take retention seriously and by definition deletion as well.
Thank you, Robert. Yes, some really great points there. I don't think I'd thought about in sort of to any great extent about the difference around retention and deletion and working at home, but it's a really good point. I wonder if we'll see, Steve, some enforcement cases coming out, you know, in a year or two in this area. Speaking of which, are there any particular examples that you can cite? I know Stephen mentioned earlier on.
Yeah, I think this area is one of growing interest. I mean, there hasn't been much in the past from various different regulators, but we most recently have seen an uptick in this particular area of retention and deletion. Most pointedly would be the Spanish Data Protection Authority, as Stephen had referred to, was that larger case, but there was actually one just a couple of weeks ago which was brought to bear, and that was to do with Equifax Iberica, where the claimant had asked for emails to be deleted. It was on their, if you like, Equifax were running their National Association of Financial Credit Institution. But if you like, behind it was Equifax, and the Equifax wrote back to the individual saying, "I'm sorry, we think it's excessive. Ta-ta." Subsequently, it got upheld. The individual concerned, you know, took it to the Spanish Data Protection Authority, and they upheld it. So they have been fined 75,000 euros. And it's, you know, the fines, the thing I like about the Spanish Data Protection Authority is the fines are almost secondary, let's be honest. This is an embarrassment. It's shining the light, as both Stephen and Robert have quite rightly said, in a lack of due process behind the scenes. You know, to turn around and say, sorry, that's a bit awkward, you know, it's going to take us a long time, is no longer satisfactory. And the other thing I would just mention is the China Civil Code that's just come into force, which has actually got 3 rights enshrined in that code, that law, and they are the right to access, the right to correct. Interestingly, they don't have a right to be forgotten, but they do have a right to deletion. And so we're going to see, I mean, you know, it's different, obviously, with the cases in China, but I think we're going to generally see a wider global lack of, if you like, tolerance for the fact that this retention issue, this deletion issue, is not being, you know, adhered to. They're not, the appropriate controls are being put in place and followed through. So I think we will see here in Europe much more on this. But increasingly, we're seeing this take a bit more of a focus around the world from different regulators.
Definitely. Yeah, you segued perfectly into the next question, actually, because I was going to ask of Robert and Stephen, you know, if GDPR is making a difference to an individual's rights in relation to retention and deletion, and clearly it is. Do you have any builds on what Steve just mentioned? Either Stephen or Robert? Robert?
Happy to jump in first. Yes, I mean, it's interesting, GDPR, because it's enhanced the rights of individuals, has caught, surprisingly, quite a lot of businesses out, probably because they weren't getting requests. There wasn't the media focus on that. There weren't the privacy groups that are pushing out template subject access requests and erasure requests and so on. But now, yes, that some organizations are receiving, 1,000 requests in a day. This is an entire business. It's not all about access. It might just be portability, or it might be right to object to direct marketing or use of profiling, etc. I think the challenge for the business is that our systems were never designed to identify the lawful ground which was relied on when you processed that piece of personal data as opposed to that piece of personal data. Individuals assume that their rights are absolute. I want my data erased. You will give me every document that mentions my name. And of course, these aren't absolute rights. So, for example, the right of erasure is only going to apply where it was either given directly by the individual to the business or where it was under contract. But what if you collected the data under legitimate interest or under a statutory duty? Erasure might not apply, and equally you might have a subject access request immediately followed by the same individual saying, oh, actually what I really want is erasure, because I don't want my lawyers seeing everything which is in the HR file because it undermines my case. I had that, and nowhere could I find which took precedence, the original subject access request or the right of erasure or the erasure request. I ran it by the ICO. They said, we haven't come across this before. We came to the conclusion you cannot touch the personal data until you have satisfied the DSAR. So for 1 month, you've got like a litigation hold on that data, and you begin to wonder whether that individual was cleverer than we thought, and he was waiting for you to doubly damn yourself because you erase the very data that you should be not erasing because you haven't responded yet to the 30-day or the 1 month SAR. And then, of course, there will be data that you must not erase because some other law, like anti-money laundering regulations, mandates you keep it. So again, I've had an aggrieved individual telling me, I'm an IT consultant and I know all about GDPR, and you will erase the copy of my passport and my utility bill, which you obtained when I asked your law firm to do my conveyancing. And the answer is, with respect, these will not be erased. We are not allowed to. So when you come to really scope out your retention policy or your deletion policy, you have to dig into an awful lot of legislation and regulation, depending whether you're in clinical trials or you're in banking or you're in education or you're a public authority. It is a much, much bigger task than we will keep data no longer than is necessary, full stop.
Absolutely. Robert, some great insights there, some really helpful advice, and I think it's probably opened the eyes of quite a few people on the call. It certainly has mine. But it does speak to the maturity of the regulation and the absolute need for precedent in this area. That felt quite heavy and quite challenging, Stephen, but ultimately, is this part of the regulation a good thing or a bad thing for organisations in the end?
Time's up.
Time out.
I think it's a good thing. I think it feeds into the accountability principle. So we're demonstrating that we're acting in accordance with the law. It's it gives companies the opportunity to improve their data quality, which I think is a big thing. As like you say, people are holding on to things for forever and a day. I have experience of a subject access request from someone who was previously managed by a fella, and now he had passed all the information on to the new the new manager, but retained a lot of it just in case. That old phrase, that old chestnut, just in case. And it was wholly unnecessary, didn't need to happen. And because of formatting issues, it meant 10,000 items had to be reviewed manually without any technological input, because they went back for so long, and it was a nightmare. And we all learned a valuable lesson that day. If you don't need it, don't keep it. And it's as simple as that. You bite size it to one thing. Do I need this data? Yes, no, get rid. It also, I think it feeds in with the Article 30 of record of processing activity. So a document of all processes within the organization, which should then also feed into the legal basis. It should feed into who has access to what, where you're going to where you're going to keep it, how you're going to delete it, and again linked with that is your impact assessments, so your privacy impact assessments, data protection impact assessments, whichever you want to call it in the current situation. Again, it prompts those questions. Are you using sensitive personal data? Are you doing something that's a higher risk to the company? If you are, call it out. How are you going to do this? It doesn't necessarily have to fit with the high-level retention schedule. It could be that's where you call out specifics, what you want to do with it. And again, the ROPA calls out the specifics of what you do. So you can have a theory of how you would deal with a particular part of data within your high-level retention schedule, but call it out. Call out the anomalies, the individualities. So yeah, I think it is a good thing for businesses. I suppose the negative side of it is the volume of it. Like we say, we've across the industry, we've seen an increase in DSARs. We've seen an increase in erasures because they didn't happen before GDPR, and we've also seen an increase in, albeit minor, but data breaches. Because also they didn't happen before GDPR apparently. So all these things feed into a better data quality and a better awareness, and having a decent sort of retention limits the risk of those things having a bigger impact.
Excellent.
Can I just add in that I'm glad that Stephen talked about the Article 30 record of processing activities, because I'm finding that the whole process is circular. I mean, if you look at some of the good guidance we've had out around collecting employee health data and visitors data and so on during COVID-19, one of the first reminders was, if you're going to be doing this type of activity, have you called that out in your privacy notice? So you're going sort of almost right back to the beginning, and then how long are you going to keep that? And why are you keeping it, and where are you storing it? And it's special category data. Have you done a DPIA? Have you added that to your ROPA? Is it now part of your retention policy? These things don't really sit isolated. All of them are cross-reference issues. And again, it goes right back to the beginning. If you don't have a grip on the data provenance, then it's very difficult to get anything else right. And that's what the ICOs, in the UK would have a look at when things go wrong, is they're going to start asking you to pull these things out from the bottom drawer.
Absolutely. And I think I'll ask of both of you then. And Stephen, you mentioned awareness, and Robert, you mentioned their data provenance. Do you think not knowing the data provenance and the need for education and awareness in this area is why some organisations find it so hard to operationalise?
Yes.
those.
From my point of view, it's a number of times where we've seen things go wrong is not because the organisation wasn't trying to do the right thing. It's just that they've gone and made a new acquisition, or part of the business has started doing stuff in a different way with the same data, but nothing is being centralized. So you make an acquisition, you've got 10 new companies, everybody's doing independent responses to the same subject access request, and it is going to end in disaster. And as I say, nobody that I'm aware of is ever a happy person when they're exercising their rights. And you've got to be prepared for that.
Thanks, Robert. Great points there. And Stephen?
Yeah, I mean, Robert makes a valid point with the individual aspect of it, and I think that's one of the difficulties about operationalizing things, is it comes down to the individual. You can have a retention schedule, you can have a policy, you can have all the rules that you need, but actually implementing that is the difficult part. It's the volume of work that people have to do. It's that incidental part that sits on the end of that is not adding value to the person's day job. So that's one of the trickiest parts about operationalizing it, is getting it at that level. Other difficulties around the metadata that's attached to it. A lot of people have, a lot of companies will have a rather immature set of metadata, which makes it very difficult to garner any information from it. And the difficulty in disposing of physical versus digital storage. It's a lot easier to press delete on something than it is to arrange a secure erasure of a box of information, and people will just put that in the corner and go, okay, I'll do that when I've got a spare 5 minutes, and that spare 5 minutes will never happen. So you just have this sat there. It brings to mind the doorstep dispensary, who had a lot of data that they may or may not have been doing something in the next 5 minutes, or in a spare 5 minutes. Maybe a bigger discussion for another day. And things like naming conventions, I think, are also one of those things that's a bit of an immature aspect, particularly as we move to a more digital culture, is making sure that things are able to be searched, that are ordered in an appropriate and consistent way. And I think that's maybe a difficult thing to operationalize, as people will say, name something as it means to them, and not necessarily with a view to how that would transfer to another person in the organization, or whether they would be passing it on to if they're not in their role anymore. It's that kind of difficulty, and with emails and shared drives, that's a consistent difficulty.
And if I can just jump in. So again, practical example we had was, young lady joins the HR team of a multinational. Her job is to take the passport and the utility bill from a job applicant, scan them into the system, give the originals back. She decides it's much easier to walk down outside into the car park, take photographs of them on her personal device, have a cigarette, come back later. 6 months later, there are 6 months worth of those things on a device which is not within the system. Actually, she didn't lose it, but when somebody made an aggressive request because they felt that they'd been overlooked for the job, nobody was ever going to find that.
No, absolutely not. A great example. Thank you, Robert. Steve, did you have, I think you put your hand up earlier on.
Great points, which was why I'm delighted we had such wonderful guests on today, and I knew that both Robert and Stephen will be a wealth of knowledge in this space. I was literally nodding my head furiously and thinking of all the examples, even at the Bank of England, where they had entire teams dedicated to this. But the one thing I just wanted to say was around, I think, Robert is absolutely right. The systems, the processes weren't ever designed for this. So we're retrospectively applying a law that were just never built into the design. So it's hard. That's really it. And then the other point about that is because of both a capability and a capacity issue. And I think, you know, Stephen touched on this. You know, people, this isn't, you don't get an ROI on this one. You know, this is an unnecessary, if you like, from a business perspective, it's an unnecessary burden, but it's something that has to be done. And to join up all the dots of both your HR, like we did at John Lewis, we split the DSARs and the rights requests between HR and the customer, because it was big, and we had entire teams trained up and we were right to, because we got inundated after GDPR, and I'm sure the numbers are still quite high. So this is difficult to do. This is one of the most trickiest things, but if you get this right, if you're luxury enough to be a new startup, and you know, this is about good data governance. This is about the entire data life cycle from beginning to end, thinking it through, working through that workflow and those journeys, and understanding that at any point that data, both unstructured and structured, may be requested. and to, you know, that fantastic example of taking photos was trying to be efficient, but you know, that's a great example. And look at us now, here we are, you know, in this awful pandemic situation where we are finding millions of workarounds because of the problem of accessibility or capacity or capability. And that worries me. So back to your earlier point, Vicky, yes, we are going to see some real repercussions coming out the back of this pandemic.
Thanks, Steve. Really nicely summed up there. We've actually got some great questions. I've just been running through them as you guys have been talking. So I think that we've been speaking for about 30 minutes now. We should go over to try and answer some of these questions in the next 15 minutes, if that's okay.
Yeah.
The first one, I would welcome some thoughts regarding email retention periods, specifically for NHS and public sector authorities. What does good look like in this area? Robert, would you mind picking up that one for consideration, please?
Yeah, happy to do that. From my point of view, you've got to step back and ask questions about why do we need to keep particular emails? Is it that there is a statutory duty to do that? Is it because it's to defend our position were there to be a complaint? Is it that there is a law that stipulates it? And you will probably find for email alone that there might be 5 or 6 or 7 reasons why you will keep different types of emails. There will be emails in relation to job applicants. There'll be emails in relation to employees. There'll be inquiries from the public. There may be, if you're running the local library, you know, in a public sector, there will be emails which relate to complaints or requests. I mean, you end up, as both Stephen and I have said, needing to do a mapping exercise of what do we have, why do we have it, where do we keep it, whom do we share it with. So the who, what, when, where, why and how is something that should be regularly revisited, and then you're in a better position to start to develop the schedule as to why you keep things. And it is a Herculean task, but doing nothing is the worst possible thing. When I know, when I've looked the regulator in the face and things have gone wrong, that if you can produce the manual and say, look, we tried to do the right thing. This is a work in progress. I'm sorry that, you know, we employed an idiot who did something wrong. You're more likely to get a slap on the wrist than something worse. So you need to be on the journey, and procrastinating is not the answer.
Great point, Robert. I think you've got a build there, Stephen, on that question.
Yes. I think for me, the best practice is, I know that there are certain companies that will restrict the size of mailboxes and things like that. I don't necessarily think that's the best way forward, because sometimes if mailboxes get full, then important information doesn't get through to that person. So I think it needs to be a little bit more robust than that, which is a little bit more dictatorial. In that you give, again, comes down to the individual and training, but maybe giving them a space, time in the week or the month to focus on retention and deletion, particularly the stuff they're responsible for, like emails, because that is the one that gets away. It is the biggest one, and it's the one that you'll just go, oh, well, it's just my emails. So file things as where you need them, but it's the ones that you don't delete or you don't file, your inbox that goes on to 3,000 entries, or bits that are unread, or meeting requests that you've already been to, just going through and having that time to have the amnesty on it. And I think it's about giving the people the actual time and making sure that they use it.
Excellent, thanks, Stephen. I think that talks to the next question, actually. The question's around a local authority with limited finances and stretched manpower. They have a retention schedule in place, but the deletion will have to be a manual process, which is very time consuming. So would you offer similar advice, Stephen and Robert, in that case?
Yes, I think it is, like Robert says, procrastinating about it isn't going to make that go away. So it's directing those resources, however small you can direct some resource to at least say, we've allocated Friday morning between 9:30 and 12:30 to do this task, to you do that on a steady basis, because doing it in one go, it can be done, and particularly where you keep things for a certain amount of time. I mean, we do an annual refresh of SARS and things within our retention period, but that's fine. That's all structured. You know that's coming, and you set time aside for that. It's the unstructured stuff that you don't see, that you don't have documented. That's the stuff that will then come and bite you on the rear end at some point.
Yeah. Sorry, please carry on.
From my point of view, again, it's the sooner you start to break the back of the legacy data, the easier in the future it becomes if you've got a proper deletion approach. The longer that you leave it, the worse it gets. It doesn't get better by doing nothing.
And I think we also recognise that it is easier said than done.
Oh, yeah.
Yeah. This is true. And the next question, again, it's a bit of an extension on, at least with emails, IT departments are likely to be able to do a mass sweep of old emails in people's inboxes. But this question is really asking, how long should we keep them? So both of you are saying, get rid of them as soon as practically possible. The person's saying, I've heard 3 to 5 years, which seems too long. I think I could see Steve out the corner of my eye suggesting that 2 years is perhaps sensible.
It's a good starting place. I mean, it is how long is a piece of string. It depends on the nature and the classification of the data. But I think less is more. And we're no longer in the. I remember yesteryear when the cost of housing all this data was so expensive, so the incentive was there. Now with cloud, obviously there's endless supply of data space, and it's 2 a penny. So, and that's part of the problem here, that we've got oh, don't worry, stick it in the cloud, and let's bury that problem for another day. That's all I was going to say.
And you've got to be realistic at the, again, real situation with a global manufacturing company where the data protection officer said that the head of legal has just told us that the new process is to avoid issues around discovery and disclosure, all emails will be deleted after 2 weeks. So how do you prove a warranty claim? I mean, it was just so wrong the other way. But yeah, 2 years would not be unreasonable. but then there might be, you know, again, we mustn't forget that you've got, say, Germany, where employee emails have to be kept for 5 years for tax purposes. So you end up having to know the nuances in all of the places where you operate.
Absolutely. So as you say, it's the organisational requirements sort of matched with regulatory requirements in different areas.
The value of data now is not necessarily in saving money on storage, it is in the data itself. So yeah, you can save all the money you like on the storage, but it's the value of the data that is housed in the cloud that then becomes the currency.
Absolutely, great point. Okay, the next question is an interesting one, actually. When I started out in marketing in the dark ages, it was common to talk about a certain type of demanding customer as a terrorist, somebody who was out to get the brand via aggressive customer service demands. This persona and their motivations became embedded in systems and processes of companies, and it took years to undo those assumptions and build a service ethos into the customer experience, which welcomed engagement, interaction, and problem solving. Is privacy in danger of doing the same with the exercise of rights? Robert?
Yeah, so it is, if you follow my thought process, that every individual is out to get you and are unhappy people. The bottom line is if you can get the process right, you do get a return on investment if you do what people ask you to do. Obviously, a lot of consumer-facing organisations have moved to preference centres for the consumer, so they are able to manage their own control of their data, and that is putting the power back in the hands of the individual, which is a good thing. Yeah, I would try and have systems that enable you to give people exactly what they want, provided you are lawfully allowed to do it. And that's the tricky bit, is remembering that you need to have a robust answer to the person who believes they're entitled to everything when they are not. And that these requests are not about documents, they're about data.
Excellent, thank you, Robert. Stephen, do you want to?
So for me, I'd say it's not necessarily a following the terrorist customer that's out to get you. You know, everyone's a customer. You know, a wise man once told me, you know, the customer may not always be right, but they are always the customer, and that's kind of stuck with me over my working life. People will expect a service, and they'll expect you to do the right thing. Or that's what they're looking for. And if you continue to do the right thing and treat customers as customers and people as people, and follow the law, and you'll end up doing the right thing, and you won't be upsetting the people that are paying for your service.
Great, thank you, Stephen. Steve?
Yeah, I just wanted to add to those great points just a second ago, that this is personally, I believe GDPR naturally is a good thing for the consumer, for us as individuals. It empowers us. I think what we are witnessing is a change of culture, and that takes time, and we need to be cognitive of the fact that that does take time to embed change, as we know, Vicky, you know, it's our whole business. So the process and the thought process even just takes a while. And I think what we are on the beginning of this journey. And I remember back to the cybersecurity days when it wasn't called cybersecurity, and it wasn't, you know, it wasn't seen to be quite as sexy as it is now, or cool. You know, and I think we're right at the beginning of that journey, if you like, and we're a little bit way off, but I understand the person's question. I really, you know, I do appreciate the fact that, but I think we're nascent industry, and we're nascent in the cultural understanding of what are my rights and what does that mean, and therefore we're going to gradually see organizations like the big tech companies are doing now, totally redesigning their platforms and their systems to be privacy enabled. That's the big change that's going to gradually come about.
Great summary, thanks, Steve. We've actually run out of time, unfortunately, and there have been some great questions today. But I'd just like to ask our guests to leave us with a couple of practical tips. I know you've given us so many, but if you could pick your top 1 or 2 tips for the people that are listening to take away and apply in this area, what would that be?
A quick win. So if you start to do this, hit the quick win, start the momentum, get the ball rolling, people see that it works. And the other one would be training. It's everybody's responsibility. So nail it with the people that are doing it, and you've got that. So there's 2 little things which will hopefully make it a lot easier.
Brilliant, Stephen. Thank you so much. And Robert?
Yeah, well, I would say make sure that you carry out urgently an audit of what you've got, that you put in place then a formal process for the retention and deletion side. And if I may, Steve, as a plug, just at this point, say part of my thoughts today are wearing my hat as the chairman of the Data Protection Network, which some of you will know of. We just completed and published earlier this month a guide on how to create a good retention plan and deletion plan. And we've got a sort of flow chart that takes you through the process, including schedules of examples of what a retention schedule would look like for, say, a clinical trial organization or education or travel, etc. I'll get you the link, Steve, maybe so that you can pass it on to interested parties. It's free, and we'd love to get feedback from people.
Fantastic, thank you. Oh, Steve.
Yeah, no, sorry. I just wanted to add my tuppence worth for what it's worth, and at the moment I'm controlling a wet dog under my desk. It's been absolutely drenched, so forgive me. No, it's just 2 things. I think the first thing, and Stephen mentioned it, I think you've got to recognise you've got a problem, and really that's, and get help, because it is a big problem. No one is unique. We all have this issue of legacy data going back. And then the second thing is, discovery and all of those fantastic tools which will really help. I think you've got to understand your user journeys, your customer journeys, the channels that is coming in. You've got to be able to map that and understand it, because you can stem it. And that's the attitude that we took at John Lewis. We sort of drew a line and said, look, okay, there's too much legacy data. Let's work out where the data is coming in, how it's coming in, the frequency, what we're capturing, etc., and work from that premise. And those would be my top tips. Recognize you've got a problem, and then start doing the user journeys and understand where all this data is coming in and going out.
Excellent, nicely summarised, Steve. I've really enjoyed today. I think it's been a really rich session, and people will have got a lot out of this, I'm sure. I'm going to play it back myself so I remember all those key points. Next week, we'll actually be talking about training and awareness, which is a topic very close to my heart. So join us again next Friday at 2 p.m. at BST. And in the meantime, if you have a particular area of concern around education, awareness or training that you would like us to focus on, please let us know. You can email us at hello@privacyculture.com. But for now, it's goodbye from me. It's also goodbye from Steve.
Bye. Thank you.
Goodbye from Robert.
Bye.
And goodbye from Stephen.
Bye-bye. Nice to be here.
Thank you so much.
Thank you.
Bye.
Bye-bye.